the other presentations of the other panelists here, but I'm guessing that they're going to be talking about something patent related. And I thought just to mix things up here, I wanted to approach the issue of how to monetize IP by looking at it from a trademark and trade dress point of view. I'm a trademark lawyer in the United States, and I want to talk about how to leverage brand equity through a specific type of trademark in the U.S. and specifically look at product packaging and product trade dress and how to maximize and build brand equity globally. So many of you may have heard about a company called Interbrand that is basically the recognized leader in brand valuation throughout the world. They come out with a report every year. This is the results from Interbrand's 2013 report, which show the most valuable brands throughout the world. I won't go into how they actually value this. That could take up a presentation in and of itself. But basically, there's a few different components they use. They look at financial modeling. They look at they have a brand index, which has about 10 different components, and then they also look at the competitive landscape, and then they come up with a number, and pretty much so based on that valuation, you see, and these are in billions. They have valued Apple as the most valuable brand at 98 billion, Google second at 93 billion, and so forth. And if you notice, all of these companies have one thing in common, with the exception of Google. Although Google itself is starting to become a consumer product company as it gets into things like Google Glass and products like that. But all of these companies are consumer product companies, and they sell products to consumers, not services, although many of them do sell services in addition to products. But all of these companies are product-based companies. And that's going to be important as I go through this presentation, because products and product packaging are ultimately what help companies build brand equity, because that is the touch point with the consumer, and that is what consumers develop an emotional reaction with. Another component of the Interbrand study is looking at how these brands break across globally in terms of value. So if in this study they did from 2013, there were 57 brands. 57 of the top 100 brands are located in the Americas. Then you have 33 in Europe and Africa, and then 10 in the Asia-Pacific region. And in the Asia-Pacific region, pretty much, at least when you're looking at the top 100, it's pretty much consists of brands from Japan and South Korea. These are all brands I'm sure everyone has heard of. When you look at India, we don't have any companies here in the top 100, but there are some significant brand owners, as everyone knows. Interbrand has ranked Tata at the $10 billion value in terms of brand equity, reliance, and so forth. And if there's one thing you notice about these companies, they are mostly service-based companies as opposed to product-based companies. And I think to break into the top 100, these companies are ultimately going to have to come up with some sort of product lines and actually sell products in addition to services. Since this is a legal conference, I want to give some background on how product trade dress and product packaging is treated, at least under U.S. law. U.S. law is very broad in the sense that it recognizes any sort of symbol, name, device as a trademark. You can build trademark and trade dress rights in pretty much anything, from scents to sounds to holograms to even colors. What I'm going to focus on here are the first two bullet points, which are product packaging and product design. Now, product packaging, just so we're all talking about the same terminology, product packaging is exactly what it means. It's the packaging that a product comes in. Product design, on the other hand, is the product itself. Now, there's two, the reason this distinction is important is because the law treats them differently.
So why is this important? Why is product packaging important? We all know we live in a very brand intensive society. Companies and brands are always competing for shelf space, and if you have a distinctive packaging and you're able to build brand equity in a certain packaging over time and help your brand stand out, that is ultimately going to make a return on your investment. In terms of how you do that, this slide I think is very informative. It shows kind of the power of brands. All of the brand names are actually mismatched with the trade dress, but I think everyone here can recognize which brands these are. And the question here is, what is more powerful? Is it the actual trademark, or is it the product packaging that everyone has grown so accustomed to recognize? In terms of how do you build brand equity, there's really two different ways you go about it, and the tests are different for whether or not you're trying to build brand equity in a product packaging or a product design. So if you are talking about product packaging or product design, the common elements of the test are two things. You have to show that the product packaging is A, distinctive, and B, that it's non-functional. So distinctiveness, there's two components to that. A product can be inherently distinctive, or a packaging can be inherently distinctive, or it can acquire distinctiveness through substantial sales and use. In terms of how you show whether a product has acquired distinctiveness, the test basically across a number of jurisdictions is similar, and it basically involves showing that the product has achieved a high degree of sales, a high degree of reputation. You look at advertising figures, whether or not the product has received media coverage, et cetera, et cetera. Sometimes you also rely on survey evidence. These are just examples of different types of product packaging and product designs. On the left-hand side are examples of product packaging which courts have actually found to be inherently distinctive. Now, the U.S. Supreme Court has made this distinction between product packaging and product design, saying that product packaging can be inherently distinctive. You do not necessarily need to show that it has acquired distinctiveness. So you don't have to make that extra showing. You don't have to show substantial sales or use over a long period of time. As soon as you roll out your packaging on day one, it is, in theory, entitled to trade dress protection. Product design, on the other hand, involves an extra hurdle. You have to show that consumers associate that particular design with your company in order to receive the benefit of product design trade dress protection. So all of these cases here, for instance, Ferrari, Apple, of course, we all know, as well as KitchenAid, in all of these cases, they had to put on survey evidence, they had to show substantial evidence of sales and use in order to get the court to grant it product design trade dress protection. The Supreme Court has also held that a single color can also be protectable as long as you have shown that it has built up substantial goodwill over time and over use. So this was a famous case in 1995 which found the color yellow distinctive for, the color green and gold for dry cleaning press pads. So even a single color, apart from packaging and design, if you're just using a single color for a product, you can have exclusive rights in that color as long as you make the necessary showing. The second part of the test for showing that your product packaging or product design is protectable is that it has to be non-functional. If there's something functional about your packaging or your design, then it's from a competitive standpoint, the courts are not going to grant you protection. So there's two ways that you can show non-functionality, at least in the U.S. The traditional rule, which is the intrinsic test, the court is going to look at whether or not the product feature, whether any of the product features is essential to the use or purpose of the article, or whether or not it affects the cost or quality of the article. So if there's something intrinsic about the packaging or the design which affects cost, quality, or use or purpose, it is going to be found functional. The extrinsic test here is called the competitive necessity test. Here, the courts are going to look at, from a competitive landscape, if I'm the court and I'm going to grant you exclusive protection in a particular product design or product packaging, is that going to somehow disadvantage competitors? Are there limited ways to make a particular packaging or design? In this particular case, you have a spray bottle. There was a company trying to gain exclusive rights in this spray bottle, and you can see even what the court basically said is that there are limited ways to make a bottle of this shape and size. It has to be a certain height due to shelf space requirements. The neck has to be a certain width because you have to be able to pull the handle. The spray, so then the bottom has to be in a certain shape for packaging purposes and shipping purposes, as well as meeting the volume requirements for this particular, for the U.S. So there were a lot of external constraints dictating the shape of this bottle, and the court basically said, no, we cannot grant you exclusive rights in the shape of this bottle because that would disadvantage competitors. This is an example where the court found that there was a recessed groove which helped consumers hold the bottle. There was a recessed groove in the middle of the bottle. The court said, no, that is also functional. We're not going to grant you exclusive protection in this particular design because that would disadvantage competitors. In this case, the company also had a utility patent. And in the U.S., if you have applied for a utility patent, that is basically going to keep you from getting trade dress protection. Utility patents and trade dress protection are pretty much at odds with one another, and they are mutually exclusive. If you have one, you cannot have the other. Design patents, on the other hand, can coexist with trade dress protection. Pharmaceutical products, can you have trade dress protection for pharmaceutical products? This has been a very interesting area over the past few years. The U.S. cases have basically said that it is very difficult to gain trade dress protection and build any sort of brand equity in pharmaceutical products because of the functionality issues. The flavor of the pharmaceutical products, the color and the shape and size, they're all dictated by external requirements. And so the courts have basically said that it is extremely difficult, if not impossible, to show that you have exclusive rights in any of those features. So for pharmaceutical products, basically trade dress protection has been a challenge over the past few years. Now, the test for infringement, this is important because when you build brand equity in trade dress protection, the question is always, if you are the market leader, you are always worried about how close your competitors are coming to your design and whether or not you should protect it. If you are not the market leader, and let's say you are a smaller company, the question is, how close in my product packaging or product design can I get to the market leader without infringing? And these questions have been played out in a number of infringement cases in the U.S. Here is one example, and I'm just going to go through a few of these examples. It's always interesting to get people's reactions to these questions. On the left, you have the Adidas shoe, which everybody probably recognizes, and on the right, you have a shoe which basically just added an additional stripe. And I just want to get a quick poll of the audience. How many people here think that the shoe on the right with the additional stripe infringes the Adidas shoe? If you think the answer is yes, that this is infringement, can you please raise your hand? So, and what about are there any no's? Does anybody think this is not infringement? Okay, so we have one who says no. Okay, so it looks like the majority here was correct. This actually was one of the most well-known cases in the U.S. at least a few years ago because it awarded a very high damage verdict. The damages were in the $300 million range after the jury found infringement, which the award was later reduced by the court, which courts sometimes do if they find the jury verdict to be excessive. And here, the district court reduced the $300 million judgment to $65 million, and $30 million of which was the royalty fee. In the U.S., if you're found to infringe, part of the damage component is how much you would have had to pay for a reasonable royalty. Here's another example. This is a case where Gateway, the computer company, sold its computers in a cow-spotted packaging, and that's the cardboard box here that's shown on the left. And then the defendant here on the right came up with this stretch toy with a similar cow-spotted design, and which is basically just something to put around your computer for ornamental purposes. How many people here think that the stretch toy with the cow-spotted design here infringes the Gateway cow-spotted design? If you think this is infringement, just want to get a quick poll. For those of you who think this is infringement, could you raise your hand? How many people think this is not infringement? Okay, so this was actually a case our firm handled. We represented Gateway in this case, and Gateway, the court actually did find infringement, and one of the key factors in the court's decision was it found that the Gateway cow-spotted design was an extremely strong brand, and the strength and equity you've built in your brand determines the scope of protection you're granted. So because Gateway had such, they had shown that they had spent tens of millions of dollars in promoting their brand, the reward the court gave them was that they were able to prevent, of course, stretch toys and computers are not competing products, but because Gateway had built such strong brand equity in its cow-spotted design, it was able to prevent a product that was complementary, a product that was related to computers, but obviously not identical. There's one more example. This is a scenario which you commonly see in the U.S. You have a national brand, in this case, it is Splenda on the left, and you have a store brand on the right. And the question here is, a lot of store brands in the U.S. try to, you can also call it a generic brand, but a lot of the store brands or generic brands try to come as close as possible to the leading national brands in order to communicate to consumers that, look, I'm a similar product, but I'm less expensive. Buy me instead of the national brand. So this is a very common scenario you see, and there are a few cases which have dealt with it. One of which is this case. How many people think that the Splenda packaging here is infringed by the store brand on the right? If you think yes, this is infringement, raise your hand. So, and what about no's? So somewhat even there. I think this is a close call. In this case, the court did find infringement, but there was also another design involved in this case, which is said was too far away, and it denied an injunction with respect to this packaging here. It said this was just too far apart, but it said this was too close. One more example. This is also another case that our firm handled. On the top, both of these companies sell motor oil. On the top, you have a company called, or the brand is Lubrigard. On the bottom, you have the brand Rotella. Here's another look at it. This is the plaintiff's brand here, and then again, you have the defendant's packaging, which you see it does have similar dual handle design, as well as similar color schemes. How many people think that this is infringement? If you say yes, raise your hand. And what about the no's? So it looks like the yes there was most people said yes. This case actually didn't come out with a decision because it settled the day before trial. But what we did as part of the case was we did a consumer survey, and the consumer surveys are commonly done in the U.S. when you're trying to show infringement. And what we did here was these were motor oil containers that were sold to truckers. So what we did is we went around the country to different truck stops. When we hired a firm to do this, and we surveyed 300 truckers and asked them and showed them this picture of the Rotella. We represented Shell in this case. This is a Shell product. We showed them the Shell product, and we asked them, do you think that the company that makes this product also makes any of these products? And so these were actually the forms of the questions, and the answer to that question, 34% of the people said yes to one of those questions. And basically in the U.S., if you get anything above 15%, that is enough to show infringement. So in that case, there was infringement. Here, again, there's a doctrine in the U.S. called initial interest confusion, which basically says, even if you, upon examination, look at two different packaging designs, and let's say, after studying them, you figure out, oh, okay, obviously, this is not a Shell product, but let's say the initial similarity draws you in to look at that packaging, that is considered infringement in the U.S. Another way that you show brand equity in the U.S. is to do a survey to show acquired distinctiveness. Now, even though the U.S. courts have said that product packaging is inherently distinctive, a lot of the times to show how strong your brand is and to show that it's entitled to a broad scope of protection, as in the Gateway case, you do a consumer survey to show that your product is strong. So in this case, we in addition to a likelihood of confusion survey, we did a distinctiveness survey, and we asked this was a separate survey cell, and 200 people we asked. We masked out any of the Shell branding and the Rotella branding, and we asked them, can you identify this product? And Shell had done a lot of marketing with this product in relation to truckers, and the results were over 54% of people were able to recognize that as a Shell product, even though all of the Shell markings and branding was removed. And this helped to show that the product and the product packaging was extremely strong and entitled to a broad scope of protection. The other point we made in this case, well, the point the defendant made in this case, was that it said, look, you're using a dual-handle container. You can't prevent me from using a dual-handle container because a dual-handle container is functional. And so what we did is we looked at other dual-handle containers on the market to counter that argument, and we found a number of different dual-handle containers to make the point that, look, there was no reason you needed to copy the specific dual-handle design. There are a number of ways to make a dual-handle container, and it was very effective to show other dual-handle containers on the market to the court. So I just want to close kind of by comparing, the patent versus trademark law. Trade dress protection is one species of how to build the IP value in your brand. One other thing that you can do is, of course, apply for design patent protection. And at least in the U.S., design patents and trade dress protection can coexist. And a lot of companies, such as Apple, in the Apple case, for instance, it brought both trade dress infringement claims as well as design patent infringement claims against Samsung. Typically, people will pursue both. There are different advantages to pursuing both routes of protection, and so you can bring both claims in infringement action. So, just in closing, as we, move forward over the next 5 to 10 years, and more companies from Asia are entering the U.S., I think, and as they roll out more and more products, I think at some point there's going to be needed some additional touch points with consumers. There's going to have to be some consumer products in order to get the Asian brands, to get more Asian brands into the top 100. And I think that day is probably not far off. And I think as companies look over the next 5 to 10 to 15 years, they should start to think about how can they build their product packaging and product designs to stand out in the marketplace, and to build brand equity as a part of their overall IP portfolio. Thanks.